This conversation is taking place at the Old State House in Dover.
We're talking with Chief Justice Myron Steele of the Delaware Supreme Court. Chief Justice, before you became a judge, what kind of law did you practice?
I was a litigator and primarily focused on hospital law because I represented the local regional hospital.
What got you interested in the judiciary and moving out of private practice?
Well, it's impossible for a litigator, someone who's in court 2-3 days a week, not to be interested in the quality of justice, access to the courts, and the way in which the courts function. It becomes your world.
Delaware selects its judges on merit selection. Is that a better way to select judges than by a popular vote of the citizenry?
Well, that's a highly debatable issue around the country. 3/5 of the states elect their judges in one form or another, and it's enshrined in their state constitutions to popularly elect judges. It goes back to Jefferson's view of the Crown appointing judges. So it's a hot topic, but for Delaware, there's no question in my mind. It's been our system from the beginning. It works. I think both the reality and the perception is it draws better quality people to the bench than it might if they had to run for election. The terms are not life terms, so they are carefully scrutinized by a small population of lawyers and people. And as a result, I think we have the best kind of selection process that could be devised. It works for us.
Chief Justice, who's behind this move to federalize corporate law? Who's pushing it?
Well, currently, and I say currently because the winds change politically. And by politically, I mean with a little p. It's not necessarily a Republican-Democrat kind of initiative. The so-called shareholder democracy movement, which is motivated largely by institutional shareholders, public employee pension funds, labor union pension funds, sophisticated organizations who believe that they should play a greater role in managing the corporations in which they invest, rather than, as under Delaware law, the board of directors under Section 141 has the authority to manage and direct the corporation. The shareholder democracy advocates believe that the federal government is the only way that change is going to occur to, they would say, empower the shareholder base. The problems with their theory are many. First, the shareholder base is not unified in its purpose. Shareholders don't all hold shares in corporations for the same length of time with the same desire to make a short-term or a long-term investment. Within the base of institutional shareholders, there are differences of opinion about how the regulations ought to change. They would argue that moving in the direction of more shareholder involvement will improve performance. The problem is they have no empirical base to show that. There's a recent study, by way of example, by Professor Davidoff from Cambridge University in England, who studied 50 years of the UK demanding that the role of CEO and chairman of the board be separated. At the end of the day, his empirical study, which is the only real way to measure performance, concluded that there was no difference in the quality of performance of those corporations who had separated the chairman and the CEO and those who had not. And to have that dictated by Congress, rather than have it be sorted out on a case-by-case basis, is the real heart of the difference of opinion between the way Delaware does corporate law and the way the nationalists, I like to call them, advocates would process corporate law.
Thank you, Chief Justice.
Thank you.
You're connected with Content Delaware.